to Crime in Court. My name is Heather, and this is an update in the Canton cover up series Commonwealth versus Karen Reed and Aiden Turtleboy Carney. And today's episode is episode number 80 Jury Foreman Foul Play and More Testing of Reed's Lexus. So let's get into it. All right. So the first thing that I want to go over with you is the prosecution has put forth just a couple of motions. We're going to go through it and discuss, and then we're going to talk about was there potentially some jury foreman misconduct going on, and we'll get into some posts that Turtle Boy got into and how the foreman got doxxed. But we're not going to dox him, so don't worry. All right, so let's get started. Please hit the like button as we begin. This first point that I want to make, this is an article from the Boston Herald. Somebody posted it on Twitter. And here it's by Lance Reynolds. And he says prosecutors in the Karen Reed case requesting additional data from the defendant's SUV that they argue would further bolster their case, pinpointing the vehicle's precise locations the morning that former uh, Boston police officer lost his life, John O'Keefe. So they're saying that there's more data that they can basically acquire from her Lexus infotainment system. And that's what the motion is that we're going to read through, one of the motions. So this article, I think, just explains it better and gives us kind of a background before we get into the motion. So Hank Brennan, who is the new appointed special prosecutor for Reed's second trial, has scheduled for late the trial, sorry, is scheduled for late January, and he is requesting, I can't read. He is requesting more testing to be conducted on the defendant's Lexus telematics system, which he said stores key evidence. Brennan filed the request in Norfolk Superior Court on Friday, so last Friday. Shannon Burgess, a digital forensic expert who'd performed the testing, has opined that significant data has likely not acquired during the chip off procedure. So he's saying that something was missing during the procedure that was done to get the data. So the procedure Brennan highlighted is a digital data extraction that physically removes memory chips from a vehicle's infotainment system and telematics systems. Mr. Burgess, through his training and experience, believes that the evidence acquired in the chip off was incomplete and that more data that was not acquired exists on the chips. So it wasn't complete, and there's more data that can be found, basically. Prosecutors are looking for track logs, which they described as an ordered sequence of GPS coordinate measurements stored by a satellite navigation system. Evidence that may be exculpatory or inculpatory, meaning it could either include Karen as the suspect or exclude her as a suspect in John O'Keefe's loss of life. Prosecutors say Reed struck O'Keefe, a 16-year Boston police officer, and her boyfriend of 2 years with her SUV following a drunken argument and left him to lose his life in the snow. John O'Keefe lost his life at the age of 46. Defense attorneys counter that outside actors took O'Keefe's life and conspired with the state and local police to frame Reed for the homicide. Reed has pleaded not guilty and awaits retrial on charges of second-degree homicide, manslaughter while operating a motor vehicle under the influence, and leaving the scene of a fatal accident. Her 2-month criminal trial ended in July when the judge declared a mistrial and jury said that they were deadlocked. So we knew a lot of that back information stuff, but or just there at the end. So prosecutors want to do some more testing on the telematics system. So let's read their uh, filing. And then I'm going to go over how there might be some errors as to what Mr. Burgess is opining here. So, this is a Commonwealth's notice of scheduling, reassembly, and testing of defendant's Lexus telematics system. Now comes the Commonwealth through its expert, Shannon R. Burgess, in the above captioned matter and respectfully provides notice to the defense in this honorable court that it intends to engage in further testing of the defendant's Lexus telematics system. Mr. Burgess has opined that significant data was likely not acquired during the chip off procedure, likely caused by programmer's error. Programmer is a technical term referring to hardware and software utilized to acquire and interpret data. So it wasn't the individual's faults, like Trooper Garino and Trooper Paul, for not getting the information that they needed and interpreting it correctly. So these footnotes just said that the CV of Shannon R. Burgess was attached, and then for the programmer part, it says see October 10, 2024 letter from Shannon Burgess and Exhibit B. So I don't think we have the exhibits here, just the motion. So continuing on, the infotainment and telematics modules from the defendant's Lexus were seized pursuant to a search warrant on February 2nd, 2022. On November 30th, 2023, so a long time later, this court, without objection from the defendant, allowed the Commonwealth's motion to permit destructive testing of the infotainment system and telematics systems due to the means and methods required to retrieve this vehicle. So basically, this testing that we're doing to get the data is going to destroy the data. It's self-destructive. So once we do it, we can't undo it. And everything else that follows, we won't be able to access anymore. So on December 1st, 2023, the defense expert Maggie Gaffney performed a procedure known as a chip-off, a digital extraction and analysis technique that involved physically removing memory chips from the Lexus infotainment and telematics systems. This procedure was observed by Massachusetts State Police Trooper Nicholas Guarino and the Commonwealth's expert AG Speak. Commonwealth had an expert AG. Oh, no, it was just, they're not an attorney general. That's what I was taking that for a second. No, it is just that's their initials, AG Speak, whoever that is, someone for the Commonwealth, who authored a report detailing the process and his findings. And that's attached as an exhibit. All right, so while a chip off had the potential to be destructive due to the technique required to remove the chips. In this case, the memory chips associated with the infotainment and telematics modules from the defendant's Lexus were not destroyed and have, along with the infotainment system, telematics system, and Lexus vehicle, remained secured in evidence. So they've been telling us this whole time, or we were all under the impression that the telematics system had been destroyed due to the testing, and therefore no more information could be obtained from it. Now we're finding out that that is not true. We are able to get more info from it, and it's just sitting right there in evidence, and they can just go and do some more testing, apparently. Mr. Burgess, through his training and experience, believes the evidence acquired in the chip off was incomplete and that more data was not required or that was not acquired exists on the chip. So, wasn't complete, more information to be found. Hardware and software updates have developed since December 2023, including but not limited to an updated version of Burla's IVE software. These updates were not available at the time of the original testing. So we're going to update our software and see if that gets us any further than we were last time. The likely deficiencies from the original testing involve two modules in the vehicle that have the capability to store data, an infotainment module and a telematics module. The infotainment module, the MMU, includes a built-in diagnostic recorder that is designed to capture vehicle operational logs. If a vehicle is equipped with navigation, the system can also record geolocation data in the form of track logs. And the footnote says Lexus infotainment systems first had a native navigation application in 1998. I don't know what that has to do with anything, but okay. Thank you for that info. The telematics module DCM also has the capability to store track logs. Navigation events can be inferred from the start and stop points of time-based tracking. In addition, the modules may contain device connections to the vehicle and separately Wi-Fi connections to the module obtained and stored as the vehicle travels. Mr. Burgess identified that two potential data-bearing components were removed from the MMU and identified a 64 megabyte flash drive component and a 16 megabyte EEPROM, whatever that is. That's going to get technical, sort of, and I don't know anything about this data technology and terminologies, but we're going to have a very smart person explain it to us once we're done reading. So the prior readings resulted in three files, 8 megabytes in size. Mr. Burgess opines that the acquisition of files in December 2023 should have been closer to 64 megabytes, believing that the discrepancy likely resulted from deficiencies in the hardware and software used at the time to interpret the data. Mr. Burgess determined that three potential data-bearing components were removed from the DCM. Similarly, Mr. Burgess identified that two of the components, Micron JWB57 and Micron ending in BAEA, likely contained incomplete data acquisition, likely resulting from the hardware and software used at the time. So they're saying it was incomplete due to the software, and it wasn't as the software that we can use now with the updates is more robust than it was at that time, basically, is what they're saying. The Micron ending in 57 only produced 540 megabytes acquisition and should have been near 4 gigabytes. The Micron ending in AEA only netted 264 megabytes and should have acquired around 2 gigabytes. We're going to have all that explained to us in somebody's tweet in a little bit, so hold your questions. Based on these likely deficiencies in acquisition, Mr. Burgess has recommended a review of the chips that have previously been removed and subsequently a reattachment of the chips to the board in the defendant's vehicle. So they want those chips that were removed to be put back. Mr. Burgess would employ updated programming and current software versions to maximize the changes of a complete acquisition. Mr. Burgess believes the use of the variety of different hardware programs and updated software will yield a more fulsome acquisition of data. Mr. Burgess has acquired a detailed outline of the procedures and efforts he would employ, and that's in Exhibit B for them to reference. Given that the testing is potentially destructive to the Commonwealth, not to the Commonwealth, sorry, given that the testing is potentially destructive, the Commonwealth is providing formal notice to the defense and an opportunity for the defense to employ its own expert to be present during the different stages of further testing. The first stage of testing would occur in Texas, and the subsequent testing procedures would continue in Massachusetts. So, this is more money that Karen Reed is going to have to put out for her defense to hire an expert and to be there at all these different times that the state is doing the testing. And that includes being in Texas for one of the tests for some reason. The testing is necessary and could produce relevant and material corroborating evidence for trial. This evidence may be exculpatory or inculpatory. Track logs are essentially an ordered sequence of GPS coordinate measurements stored by a satellite navigation system. Unlike telephone satellite data that are employed in triangulation analysis to place a cell phone in a general area, track logs provide specificity. Generally, track logs are points that are automatically stored when a device is moving. The information is tantamount to laying down a breadcrumb. So we need to know this to be able to retrace all of her steps. It's vital. These points, these tracking points. Um, to lay down the breadcrumb trail, memorializing travel by location and time. The download analysis by Mr. Burgess and use of other software may also provide information about any other devices connected to the vehicle, such as a phone, and could potentially identify any Wi Fi connections that would identify by the vehicle as it traveled on its route. So if she passed, let's say, a home that she know that's a friend's house who babysits the kids or whatever. Maybe she drives past their house. She babysitting John's kids, meaning, they were friends with John and Karen and she has a connection to their Wi-Fi perhaps and she drives past it. It should pick that up potentially. Just as an example. All right, so in the case at bar track log information is significant. If track log and other various data information exists, it will serve many important functions. The benefit includes corroborating the defendant's travels before, at the time, and after the defendant's Lexus vehicle was involved in a triggering event, if there even was one. If track log and Wi Fi information is retrievable, the data would provide independent corroboration to the numerous witnesses who made observations that the defendant's Lexus was parked in front of the Fairview Road address after midnight. Further, the data would identify the location of the defendant's vehicle at the time it engaged in the impact event, if it did have any impact event, and provide the time and location of the defendant's travel from the scene to the location of Mr. O'Keefe's home. Commonwealth provided and introduced at trial video depicting some of the defendant's travels on January 29th. The additional data likely to be retrievable would assist in identifying the precise locations that the defendant's Lexus traveled from the time that the defendant struck and took John O'Keefe's life. Mr. O'Keefe, not Officer O'Keefe, as they often forget to call him, until the time the vehicle was seized. So they want all the data points from basically showing up at Fairview Road to when she went back to John's. Commonwealth respectfully requests a hearing within the next 14 days to permit prompt testing and production of relevant discovery, whereas this matter is scheduled for jury trial in January 2025, and this was signed by Hank Brennan and Adam Lawley and Laura McLaughlin from District Attorney Michael Morrissey's office. And that is, oh, and here was an order that people all thought that that it had been officially ordered, but no, they just kind of wrote this up so that the judge, to save the judge time, like, here, if you were going to grant this, here is what you could say. So they presented this with their motion so that the judge could just easily date and sign it if she wanted to, or, modify it. So the Commonwealth's proposed order permitting reassembly and testing of defendant's Lexus telematics system. Upon reviewing and hearing on the Commonwealth's notice for reassembly and additional testing of defendant's Lexus telematics system, it is hereby ordered that testing may occur to acquire the vehicle's data. It is hereby ordered that should the defendant seek to have their own expert present for testing, they provide the Commonwealth the name and contact information of their expert within 7 calendar days. 7 calendar days, that's pretty short timing, but as you can see, it is not dated or signed, so this is not an official order. Judge Canoni has not ordered this. I almost called her Judge Gull. To me, Judge Gull and Judge Canoni are one and the same. If you're following the Delphi case too, they are very similar, except Judge Gull wants to keep everything secret from the public, and there's no cameras or audio even in the courtroom, and very few press can even attend. But that's a whole nother story. All right, so that is the, oh, before we get into the next topic, I promised you a better explanation of all of that gobbledygook that is data that I can't understand. So, this is Olivia Lambo. If you are on Twitter and you um, want to know a lot of details about the Karen Reed case, I would recommend subscribing to her. She's got over 17,000 followers, so definitely go find her. And she gives great explanations of things, and she also provides the list, discovery or motions when they come out. She puts filings out. So, all right. So here she says the Commonwealth's latest expert, and she puts that in quotes, Shannon Burgess, is in his analysis of the prior data acquisition of Karen Reed's Lexus telematics system doesn't seem to understand the rather basic difference between gigabits and gigabytes. This means Burgess's entire analysis is incorrect. He states the micron ending in 57 only produced 540 megabytes acquisition and should have been near 4 gigabytes. The micron ending in AEA only netted 264 megabytes and should have acquired around 2 gigabytes. The memory, so that's what he said. The memory IC data sheet for the micron part confirms that it is a 4 gigabyte flash drive or flash memory. The memory IC data sheet for the micron ending in AEA part confirms that it is gigabits. So gigabits is the lower B, gigabytes is the large B. So he said gigabytes, 4 gigabytes and 2 gigabytes, and we're finding out it's 4 gigabits and 2 gigabits, which is a huge difference when it comes to size and the conversion rate. So we'll get into that. So a 4 gigabit, the 4 with the little b is gigabits, whereas 4 with the big B is gigabytes. Shannon confused gigabits for gigabytes. They are not the same. As the big old dog, another person you can follow here, which I'm not. So here we go. Let's give him a follow. The big old dog explains a bit is a single binary digit, A1 or A0. A byte is 8 bits. 1 byte is 8 bits, so that's a lot bigger. So 4 gigabits is four. The 4 with the little b is 4 gigabits. So to convert bits to bytes, you divide by 8. Every 8 makes 1 byte. So 4 gigabytes is almost half, or is half of a gigabyte, if that makes sense. So 4 gigabits divided by 8 and you come up with your half a gigabyte. We go from lowercase b to uppercase b. Now, to convert gigabytes to megabytes, you multiply by 1,000. So 1,000 equals 500 megabytes. So the Commonwealth and its new experts seem to think 540 megabytes wasn't the full data acquisition of the one ending in 57 part because they think that it's 4 gigabytes, if that makes sense. So but it's actually 4 gigabits. In other words, the 540 megabytes acquisition that was made from the 4 gigabit micron part means they got the full acquisition because 4 gigabits equals 500 megabytes, which is what they received. So they basically, this expert, and that's why she puts him in quotes, because he has been getting annihilated on the internet by internet sleuths who know what they're talking about. All right, next, where was I? So yeah, so they are claiming that they didn't get what they they were claiming that the sizes are supposed to be bigger than what they actually received, but when you do the conversion to shrink it back down, you are getting the exact same size as what they did receive in their acquisition. And similarly, a 264 megabyte acquisition that was made from the Micron ending in EA part means that they got the full acquisition for that too, because 2 gigabits equals 250 megabytes. See, so that is, these match 250, 264. That's where they're getting it. The same here, the 554 megabytes matches the 4 gigabits, which is actually 500 megabits. Do you guys see what she's saying here? Do you see how she explains it really well? So how or why their expert is conflating what is an important unitary distinction, that is the difference between the units GB, the gigabytes, and G lower b, gigabits, sometimes written as gbits, is deeply concerning. So an expert that doesn't understand that, that's a problem if they can't figure out what's a gigabyte and a gigabit. Based on my research and understanding, again, back to Olivia, this is a rather basic and fundamental concept that a real expert with deep understanding of their field would know. To confuse something so rudimentary, naturally, has to make anyone question the competence level of this new expert. And this is the expert who the Commonwealth wants the court and the defense to have confidence in his ability to competently conduct a destructive process to critical evidence. That's right, this person who can't even determine the difference between bits and bytes, who's supposedly a digital forensics expert, wants to destroy the evidence with his testing, and we're going to allow him to. Huh? This is hugely embarrassing for Hank Brennan and the Commonwealth, as it highlights yet again how unserious they are, how little they can be trusted with what's deemed important evidence, particularly given how the Commonwealth's filing, Brennan and Burgess went on and on, concocting this fanciful narrative about what the evidence would show, that it would show Karen Reed's guilt, which it just reveals their bias given they haven't even seen the evidence yet, so they have no idea what it would show. But it's also just categorically wrong given they already acquired all of the data. There's no more to acquire. The stuff that they claim would show Karen's guilt, it doesn't exist. But go ahead, spend more resources of the Massachusetts taxpayers to do more testing on something that you're just really trying so hard to find anything that you guys can grasp at. So my question is, back to Olivia's post, if that's the care with which Hank Brennan, the Commonwealth, and this expert Shannon Burgess treat what they claim is important evidence, how can they be trusted with their handling or interpretation of any of the evidence, particularly when it requires a potentially destructive process? Agreed. So she has some images here. Let's go through them. She's just highlighting here what we already went through, which was what they're saying they acquired. So the Micron ending in 57 acquired 540 megabytes, which is what, when you do the correct math, is what they got. And then also the Micron ending in AEA only netted 264 megabytes, as he says, but that is, as we know, with the correct math, we have 250 megabytes and 500 megabytes. So seems like it was done correctly the first time. And this is just more evidence showing this is the 4 gig flash Micron. And can't read that, but this is just, I can't zoom in, but it says device size 2 gig. And so that's talking about the Micron flash memory. So this is just like the scope of how much it holds. So that is exactly what they got. The gigabytes equals the 240 whatever megabytes. So when you do the right math. Finally, oh wait, one more here. What was this? Oh, we looked at that. Never mind. Sorry. Here's the last one. So as you can see, if you do a G bit to an MB conversion, you have 4 bits, 500 megabytes. 2 bits, 250 megabytes is the conversion. So she's just proving the math here. So as you can see, we all got there correctly, and Shannon Burgess did not. So that's pretty embarrassing for the Commonwealth. What do you guys think about that? I think it's humiliating, absolutely humiliating for Brennan with that. Just with the fact that, internet everyday Joes are like, no, man, you guys are wrong. And here's why. And they prove them wrong with evidence. It's just great. All right. So the next motion that they filed last week on Friday was the Commonwealth's notice of discovery, whatever number that is. So now comes the Commonwealth in the above caption. There's like 60 items on here, so I'm just going to try to go through it really quick. Now comes the Commonwealth in the above caption matter and indicates that as of this date, the following discovery and materials have been provided to the defendant through defense counsel. So they got a letter from Chief Helena Rafferty of the Canton PD dated 8/21/24. Copy of a Canton PD Sallyport video that was recorded and inverted. It says as recorded, inverted. Like how they have to make sure that they put that in there because they know they screwed up. Canton Police Department interior hallway video, exterior parking lot video. Oh, that's interesting. Hallway video to see if, people were walking in and out. Copy of curriculum vitae of Colleen Crawford. There must be a new expert or someone that they plan to call a witness. Quick hash report of Colleen Crawford, same woman. Extracted frames of Colleen Crawford. Extracted images from the frames in the report by Colin Crawford. Copy of a clarification report of audio file from Colleen Crawford also. So she's got to be an expert. This has to be her materials that she's bringing back or bringing to the case. The converted, reduced speed, amplified audio, voice mail message with and without text overlay of Colin M. Crawford report. Copy of surveillance video clarification report of Colleen. Canton PD Sallyport videos. Clarified images from Canton PD Sallyport. What's a clarified image? Better, like, did they try to clean them up? Copy of grand jury minutes and grand jury exhibits. Copy of updated Cellbrite report of web history regarding Jen McCabe's phone. This report was run on 9/17/24, so way after the events took place. But nonetheless, it was done on a Cellbrite this year recently. So they took an extraction of Jen McCabe's phone, which is excellent. Let's see if they actually turn it over to the defense accurately. Copy of Birchmore materials pursuant to the Massachusetts Public Records Law. So that's interesting. They're bringing in Birchmore materials. Wonder how that relates. Obviously, we know some of the individuals were involved, like a Kevin Albert and a Michael Lank, and I believe Sergeant Good was there. There were a bunch of Canton PD that arrived at the scene and investigated Birchmore's homicide. So that's I assume those are probably the materials. Maybe they could impeach Lank or something on the investigation on that. All right, a copy of curriculum vitae of Brian Tully Massachusetts State Police Crime Laboratory Forensic Services Division Serum Conversion Factor Update Memo. So this is to do with her blood alcohol and how they did the serum conversion to make her seem way intoxicated when it's based on a guess. All of that evidence is based on a guess. Copy of Massachusetts State Police report regarding complaint investigation. Copy of Department of State Police personnel order. Copy of Massachusetts State Police Division of Standards and Training report. MSP Division of Standards and Training findings concerning internal affairs investigation. Ooh, I want to see those because Michael Proctor is still currently suspended without pay. As far as we know, they have not, as of yet, terminated him, which I believe will be the next step. I think they're waiting on this trial, to be honest, because it makes them look even worse if he gets terminated. Copy of curriculum vitae of Judson Welcher, so it must be another expert. MSP report dated 9/27/24, 9/30/24. Photographs of cars from MSP report. Whoops, that's not a date. Mass, the Massachusetts State Police report case dated 10/2/24. So these things are this year, like this month. They're doing testing or handing over discovery from this month. What is the MSP report dated 10/2? What's in there? What new information do you guys have? Copy of ring video of One Meadows Ave. Oh, we know One Meadows Ave. We've got that. We're looking for ring video from across the street of 34 Fairview. That would be great if we had that. Because we know two of the houses across the street had ring cameras, but it was never obtained. Copy of Massachusetts State Police report dated 10/2/24 again. Another report 7/10/24. Administrative report. Another administrative report, a closeout report, some exhibits from MSP. All of this is MSP dated in recent months here. MSP investigative report, copy of MSP digital evidence report, MSP administrative log note, from several log notes, several property release receipt. What's that? They released somebody's property? What did they release? And to whom? Interesting. And why is it relevant as discovery? You know, I don't know. Administrative log note, many log notes. So that's interesting. From August, mostly, and July. MSP Office of Professional Integrity and Accountability report. Copy of Canton Police Department incident report. What incident happened? A CV of Hannah Knoll, so her curriculum vitae. Copy of MSP Crime Lab Forensic Services Division serum conversion rate, some more of that. Copy of MSP Crime Lab retrograde extrapolation report. So again, that has to do with the blood alcohol report. And this was also signed by Hank Brennan. The other two did not sign it for some reason. They're not on there, but whatever, it doesn't matter. So that is what I have for you regarding the Commonwealth's motions. Kind of weird that they are doing all this testing, and now we know that they did their calculations wrong. Their new expert, and all this new discovery has just been handed over to the defense. So they have to go through all of that and make heads or tails of it. So that's fun for them. All right, so now let's get into the jury foreman. So the title, like I said, is Jury Foreman Foul Play and More Testing of Reed's Lexus. So we've already talked about the Lexus. Now let's get into the Jury Foreman Foul Play. And I say that with like a foul play question mark because was there some kind of foul play that happened. So over the weekend, October 13th, 2024, at 7 p.m., Aiden Carney posts. Aiden is Turtle Boy, if you are not aware. He posts, "Do you think it would be newsworthy to point out that the jury foreman in the Karen Reed trial left his job as a police officer after being hit by a car?" So this is brand new information to us, at least, to me, to most of the public. This individual apparently is the jury foreman. We know he was a police officer, and we know he's now uh, a physician or a physician's assistant or something. He's in the medical field now. But um, we did not know. We knew he had a law enforcement background. We did not know that he left his job shortly after being hit by a car. He also goes on to say in his tweet, "What if he failed to mention this during jury selection and then immediately started subscribing to anti Karen Reed Twitter accounts the moment the trial ended?" So, for those of you again who think that it's not possible to plant someone on the jury, I say think again and stop harassing me. You know who you are. Because this is happening. This is real. This person lied during jury voir dire, according to sources, according to Aiden and his sources. And usually Aiden doesn't claim something unless he knows it to be fact. So I'm just putting that out there. I do want to mention just briefly. So there was a whole lot of drama that went on with this because people are like, "Oh my God, you're doxing the juror." He didn't say the juror's name. He's never said the name. He's known the juror's name for months, and he's never come out and said it. And first of all, if he did say it, it's not against the law to say it. The thing that people need to realize is that there was a so let me backtrack. Anytime there is a trial that takes place, you have a jury. The jury's names are usually kept under seal up until the trial ends. After the trial ends, those names are made public, and anyone from the news, the media, anyone from the public can go out and see if they can not hunt, but like find that person and ask them questions if they really wanted to. It's how system has always been, because you don't want secrecy. You need transparency, and that's why you need the jurors' names and information made public after a trial. Although I think it's the OJ trial that still the jurors' names have not been made public. They've been kept under seal. There's one like famous trial, or maybe it's the John Ramsey case. I can't remember now, but one of them, like they indefinitely, the jurors' names will remain sealed, except I don't think that it should be that way. We need transparency, and we need to be able to see who we're facing in a trial, who your peers are, because this person is not a peer. This person is not friendly to Aiden. Based on the things that have been said, the things that have come out since, we know this jury foreman refused to go to Bev and say, "Hey, we've got a question. We've acquitted her on charges 1 and 3. What do we do? Can we have a split verdict? Can we announce that? Do what do we say? How do we deal with that?" They never. The jury foreman specifically said, "No, I'm not going to do that. I'm not going to ask a question to the judge." And for some reason, everybody was like, "Okay, well, the jury foreman just has all the control and power." That's not true. The jury foreman is just some rando that's selected, usually. In this case, I think it was not random. I think it was selected on purpose, because I think this foreman is a plant or potential plant, or at least was compromised in some way because of what we're finding out now. So, anyways, um, what else was I gonna say about this? So this juror got doxxed apparently. Once Aiden made this first couple of posts, people started commenting, and somebody posted like his LinkedIn, and somebody posted an article about an officer that got struck by a car, and people started putting two and two together because of the information given. Aiden did not out him. Aiden did not do anything to out him. He simply brought up a text to say, would it be newsworthy if such and such happened? Well, the whole under seal part was because, those names, those juror names, which I was getting to in my long telling of the story, those jurors' names that are usually made public after trial, the jury, the juror, the foreman himself, was the one who wrote that affidavit with his lawyer and said, I'm fearful because people are being harassed and intimidated and blah, 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 blah. And he made a lot of references to Aiden in that filing, but he wanted the names of the jurors filed under seal, which just means the court cannot publish those names. Doesn't mean that if you already know those names, you can't say them out loud in public or on a social forum. You have every right to do that as a citizen with First Amendment rights. There's nothing binding saying you can't put those names out. So nobody did anything wrong. This guy is not necessarily doxxed in the sense that like they put out his address and all that, but his information has now been made public, at least his name. I think. I don't even know if I know for sure who it is, but um Grant Smith Ellis, if you're familiar with him, he got removed from the media, the press area during trial because he bumped into, or well, he assaulted Jess Machado, who is another reporter in the media line outside, and so she got a restraining order. He was no longer able to attend, which made things so much easier and better for the rest of everybody there. But this person, Grant Smith Ellis, had posted on his Twitter account that he basically confirmed, yes, I can confirm that's the guy based on his based on me looking at him for however many weeks. So if anybody doxed anybody, it was Grant Smith Ellis. Again, he didn't do anything wrong, and it's not illegal, and it's not unethical. So for everybody like, oh my God, Aiden said the guy's name. No, he didn't, first of all. And second of all, it's not a big deal if he had done it. So all right, so shocking news overnight. A Twitter account with a small following made a post identifying who they claim was the juror foreman in the Karen Reed trial. Although I have known the identity of this juror since July 1st, I have chosen not to report it out of respect for the sanctity of the judicial system. Rather than ignore this post, which was not seen by many, supporters of the McAlberts have chosen to amplify the tweet by responding to it, giving the tweet more visibility and drawing more attention to the jury foreman. Then, shockingly, reporter Grant Smith Ellis confirmed that he could personally identify the person in question as the jury foreman based on the visual identification from court prior to him being banned for assaulting a woman in the courthouse stairs. I condemn Mr. Ellis, Smith Ellis, for doxing in the strongest terms. So Grant was the one that confirmed it. This is part of Grant's tweet. He says, "This is the jury foreman." The page is cut out. You can't see his image, but that was what Grant had put on X. This is the jury foreman from the Karen Reed trial picture with this post. Former cop who left his job after being hit by a car. He didn't think that was important information to divulge during jury selection. TB's juror interview gives insight into how this guy operated. He believed he was in charge. And somebody's eye roll and clown. Or maybe this is the tweet from the person who outed him. I'm not even sure because it doesn't say. And I didn't see it. So, but whatever, whoever posted this had a picture of the individual with their name on their LinkedIn page. So, Grant Smith Ellis says, new overnight, a follower of blogger Aiden Turtleboy Carney himself under investigation for jury tampering. He's not under investigation for jury tampering, so let's make sure that that is clear. He is under investigation for witness intimidation, which is bogus charges, but jury tampering, no. So he's wrong about that. So Carney has doxed the foreperson of the jury from the first Karen Reed John O'Keefe trial in violation of an active court order protecting juror identities. Whoops, whoops, whoops. Trying to, I can't scroll down, sorry. All right, so the public post on social media late Sunday night, which I will not be releasing in an unredacted form, was a screenshot of a social media profile that matches with a juror that I personally saw in the courtroom sitting in first chair. This person was eventually selected as foreperson, so he is the one that outs the guy. So other people speculated. They said, we think this is the guy. That's speculation. Nobody has confirmed it. But now Grant Smith Ellis confirmed that is the one, the picture that was going around. So if the court will take action on this flagrant violation of an order protecting juror identities in the case is unclear. So it's funny that he's asking if the court is going to do anything about this flagrant violation, when he's the one that's doing the violating. So I just think that's quite hysterical. All right, so this next tweet again is from Aiden. This is all the Twitter drama. I'm trying to keep you out of the most of the drama. I'm just giving you the basic facts. So here, Aiden is saying receipt of me being informed about the foreman's identity on July 1st while juror deliberations were still ongoing. So trial had not concluded at this time, and Aiden was getting messages about the foreman talking about the case. So that is a violation, and that itself is misconduct. And if the person also lied on their jury questionnaire, that's also misconduct. So let's keep reading. He was going around bragging about being the foreman and did some other things I haven't yet made public. Despite the fact that he was telling lots of people he was on the jury, I still chose not to ever mention him. I cared about protecting the privacy of the jury more than he did. Since then, 2 jurors have reached out to tell me their stories and specifically mentioned how they felt comfortable doing so because I didn't identify the foreman. Jurors are safe with me, not so much with Grant Smith Ellis. So he's reiterating that he's had 2 separate jurors reach out to him to do anonymous interviews. He's kept all of them anonymous, just as the foreman, who he has not interviewed, but he still has kept the juror's information anonymous, as he said. So here is the text somebody sent to Turtle Boy. Says, is the juror's foreperson. He says, can I ask how you know that? Wow, that's definitely him. So I think the person sent him a picture and Turtle Boy's confirming, not publicly to privately to whoever's contacting him. He says, wow, that's definitely him. This person continues on, says, ex-cop, he told me he was working the case and told me he was the foreman. So him talking about the case and talking about being the foreman on the case is not really acceptable. What else was he saying? Was he, how deep was his conversations going? And in working the case, you're not a cop anymore. You're not supposed to work the case. You're not supposed to solve the case. You're just supposed to be a foreman, which is an intermediary between the jury and the judge, and you communicate back and forth. That's all the foreperson is supposed to do. Not solve a case, not work a case, not convince others that the person is guilty of manslaughter, potentially, I'm guessing. So, yeah, this is extremely problematic to me that this person was talking and bragging about working on the case and being the foreman. So let's look really quickly. This is going to be the last thing we go over. I'm going to go over some questions on the jury questionnaire that might have led to digging deeper into this particular juror's background if they answered correctly, if they answered honestly. So let's see. There's a few questions here that, you could answer dishonestly and, not get questioned about. So let's see here. It is alleged that on January 29th, 2022, while intoxicated and operating her motor vehicle in Canton, the defendant, Karen Reed, took the life of her boyfriend, John O'Keefe, an off duty Boston police officer. Is there anything about that description of the case, the charges, or that the victim was an off duty police officer that causes you to believe that you cannot be fair and impartial in this case? Well, let me take a minute and think here. So, this guy is a retired police officer who left the force because he got into a car accident. So, a law enforcement officer got hit as a pedestrian by a car, and that doesn't what? It's exactly like a situation that he's been through. So, I would say that yes, you would probably be a little unfair if you were hit by a car and this happened to you. You might think, oh, well, the person's guilty. Screw the evidence. The person's guilty because I've been through something similar and I didn't get my justice for whatever reason. Some people can be biased for any reason. I'm just giving a few examples and speculating. All right, so number 8. Is there any reason you would be unable to follow an instruction that during your jury service you may not read any news or media accounts about this case, watch or listen to any media or news broadcast or commentary about this case, discuss the case with anyone, research or look this case up on the internet, or perform independent research? Obviously, that's pretty standard, but this guy might have been doing this. I'm not saying he has. Hold on. Sorry, my dogs are getting impatient. They want their FOOD, and it's not time yet. All right, so this question I highlighted because though it's doing research on outside media, we know he was talking about the case and saying, hey, I'm the foreman and I'm working the case. So was he doing outside independent research or looking up stuff with the media? He knew about the witness intimidating charges about Turtle Boy in his affidavit, which came out just a few days after deliberations ended. So he knew about that. He subscribed to a bunch of people who had, and he even referenced people, pro anti Karen Reed people. He referenced in his affidavit. I just remembered. So yeah, he was already like following people on Twitter that had a very biased view of Karen and think that she's guilty. And he was um, and he put it in his filing. So, sorry, I'm just kind of thinking like, wow, I think he really did. I think he really did do his outside research because it was like almost immediately after trial he started following these accounts that he referenced in his affidavit. So it's strange to me. All right, number 9. Is there any reason why you would be unable to follow an instruction that during your jury service you may not read or view any social media, articles, posts, videos, podcasts, or any other non traditional media platforms that may discuss this case? So, again, I think he might have been doing some independent research. 11. Would you automatically believe or disbelieve law enforcement, firefighters, or first responders simply because of their occupation? That one definitely what he said, and if they asked him any follow-up questions on that would be really important. Do you have any strong personal beliefs, or have you been exposed to any strong personal beliefs from friends and relatives about law enforcement officers, prosecutors, or the government? So, similar fashion, similar kinds of questions. Have you ever been involved in a group, community, or individual activity such as a march, demonstration, or financial contributions showing support for law enforcement in or outside your community? So, have you protested or done a walk for law enforcement? Have you contributed financially to law enforcement charities or donations? It's a good question to look into and to see if he answered truthfully. Number 15, have you or someone close to you had an education, training, or work experience in any of the following fields: law enforcement, military, alcohol/drug abuse, and DV. So those are all good questions to know what his answers are. And if he lied, if he answered these dishonestly, then why would Karen's attorneys really push them on it? You know what I'm saying? If you said no to all of these and there wasn't an opportunity for them to ask questions about it, that's bad. That's big. That could potentially lead to charges, maybe. But who knows? We're still waiting on perjury charges of all the people that lied on the stand. Do you have any strong personal beliefs, or have you been exposed to any strong personal beliefs from friends and relatives about operating a motor vehicle under the influence of alcohol? Has anyone close to you ever been involved in an accident involving drinking and driving? If so, ex- would that experience prevent you from being fair and impartial? Have you or has anyone close to you been involved or witnessed a motor vehicle crash? Again, I would love to see his answers and any follow up questions on these. And finally, you may find a defendant guilty based on circumstantial evidence, but you cannot find a defendant guilty based on speculation, guesswork, or surmise. Is it difficult for you to understand the differences between circumstantial evidence, speculation, guesswork, and surmise? And I point that out because even though he's law enforcement, it should know the difference, or former law enforcement, I should say. And he should know the difference between all of these. That doesn't mean he does, and that doesn't mean that he won't use guesswork and speculating to come to a conclusion, especially when he's quote unquote working the case according to his own words. He told me he was working the case and then he was the foreman. So that's what I have for you regarding the foreman. I hope that clears some things up. If there's more that comes out about this, I would assume Karen's attorneys might have some things to say about this, especially when they go to the SJC to argue dropping charges 1 and 3. So we shall see what comes of this. I will keep you guys informed. Please don't forget to hit the like button on your way out, and also make sure you are subscribed so that you don't miss any Canton cover up episodes. I will see you guys in the next one. Thank you so much for watching. Take care. Bye now.